The United States Supreme Court has upheld its landmark 1966 Miranda ruling, which requires police to warn suspects of their right to remain silent before questioning them. In Salt Lake City, Paul Cassell is with the University of Utah Law School. He is a staunch opponent of the Miranda warning. Mr. Cassell, good morning to you.
Good morning, Jane.
You argued to the Supreme Court that Miranda should be overturned. Why?
Well, the tragic result of rules like Miranda is that thousands of confessed and dangerous criminals go free simply because police or prosecutors make some kind of mistake in dealing with the highly technical Miranda rules. You mentioned this case where now the jury will never hear that Mr. Dickerson has voluntarily confessed to driving a getaway car from the scene of an armed robbery.
All right, let me get another point of view. Her attorney, James Hunley, represented Mr. Dickerson, and he tried to get his confession thrown out of court. He's in Washington. Mr. Hunley, good morning to you.
Good morning.
Why is it so important that a criminal be read his Miranda rights, and in your case specifically?
Well, because any individual who is under suspicion of a criminal activity needs to know what his very fundamental individual rights are before he agrees to waive them and subject himself to criminal prosecution, before he agrees to provide incriminating statements which will then be used against him at his trial.
Well, the National Association of Police expressed great disappointment with this ruling and said if an officer makes just one misstep and doesn't give the Miranda warning, any incriminating statements, any confession can be thrown out in a court of law.
I disagree with that characterization of the Miranda rule. I believe it's a rule that not only serves to protect individual rights, but is a great tool for law enforcement and the courts as well. It's a very simple, straightforward rule. If it's followed by the police correctly, which it is in the vast majority of cases, police officers can rest assured that the evidence they obtain will be admissible.
What about that, Mr. Cassell?
Well, there are a number of cases every year in which police or prosecutors make a mistake in dealing with the Miranda rules. The best evidence is that about 3,000 cases every year will be thrown out simply because police or prosecutors have had some problem with the highly technical Miranda requirements. The Supreme Court mentioned yesterday that they have had more than 60 decisions dealing with the Miranda rules over the last 30 years. In my law school class, we look at 120 pages of issues dealing with Miranda. So it's much more than reading just a few words off of a card. There are lots of ins and outs, and the net result is that too often truth is thrown out of the courtroom.
Mr. Cassell, are you surprised at this decision coming from the so-called very conservative Supreme Court?
Well, the decision is so brief and leaves so many questions unanswered that I think a number of justices could join it. There are a lot of questions that will have to be resolved down the road. For example, is there a good faith exception to Miranda? What do we do in cases where police officers reasonably acted, yet for some reason courts later on decide that they've made a mistake in applying the Miranda rules? I'm hopeful that in a later case, the Supreme Court will recognize that in that situation, voluntary confessions can come into evidence.
Mr. Hunley, in this decision, Chief Justice William Rehnquist wrote that Miranda has become embedded in routine practice to the point where the warnings have become part of our national culture. Everybody knows that phrase, you have the right to remain silent. Is it really necessary for police to read it?
Yes, it is necessary, because before an individual's confession can be admitted into evidence against him, the court has to have evidence that this individual knew his rights and knowingly and intelligently waived those rights. So there has to be a record created before the court will acknowledge a waiver of this very fundamental individual right.
Mr. Cassell, I'll give you the last word here. What, in your opinion, are the consequences of this decision?
Well, the consequences is that juries are not going to get all of the information they need to convict the guilty and acquit the innocent. They're not going to hear that Mr. Dickerson has confessed to robbing the bank. I think that's a tragic result in that particular case, and it will have tragic consequences in many other cases around the country.
All right. Paul Cassell, James Hunley, my thanks to both of you gentlemen. Thank you.